Thanks once again to ThuggerDaily. We already have the order to show cause document. Let's roll through a recap of what happened and then we'll read through that order to show cause. A lot of spicy stuff happened today too, although in a short period of time.
Do we know if Ms. Bumpus has rejoined us this morning?
So the judge wants to make sure Ms. Bumpus is in the room. Now that was the attorney that was representing as a stand-in Kenneth Copeland, or Woody, while he was part of that ex parte meeting in Chambers. There were rumors floating around yesterday that he tried to fire Ms. Bumpus.
Excuse me, Your Honor, may I bring something up before Mr. Copeland comes in?
Go ahead.
I believe I heard him say on an open mic yesterday, gave this testimony, that he may take the fifth today. Can you inquire into that prior to the jury coming out?
I didn't hear him say that, but I can.
Thank you, Your Honor.
So now they're going to see if Woody's going to take the fifth, and Shart's going to ask for a copy of the transcript.
Pieces of business I have to do, at least for the record, renew our motion for mistrial.
Denied. What else?
Instant denial.
Again, requesting for the purposes of cross-examination, the transcript from yesterday.
I'm deferring on that one for the time being.
Thank you.
All right.
So he's deferring on the question of, can you produce the transcripts from yesterday? He's deferring on that, but these attorneys want their hands on it because the witness that was involved in that ex parte communication, he's already sworn in. He was sworn in on Friday. He's still on the stand. He's still under oath. We're going to be approaching cross-examination. It won't happen today, but maybe tomorrow. And these attorneys will want to be able to cross-examine him on what they can involving that ex parte meeting, what agreements were discussed, and anything else that could be fair game. But yesterday, when Brian Steele first raised his concern about this ex parte communication, Judge Glanville was like, well, what's there to worry about? It was transcribed. It was recorded. So he's using that transcription as both a sword and a shield.
Do you have something, madam?
Yes, Your Honor. I just wanted to say for the record that that is not his position. He explained yesterday, I believe that he had...
You talking about he being Mr. Copeland?
Yes. What he said, and I was standing there when he said it, was that his head hurt. And if y'all don't let me go,
Is this at the end of the day?
Yes. At the very end of the day. He did not state without qualification, I'm going to plead the fifth. He said, if y'all don't let me go, I'm about to plead the fifth again. He has given her no indication that that is his intent.
We'll find out. We'll find out before the jury comes in.
And if you missed it yesterday, here's what happened.
I got a headache.
We'll be in recess 10 minutes.
I'm going to take the fifth.
So back to today, day 89, the judge needs to get clarification on this before he takes a stand again.
All right. Sir, is it your intent to continue to testify today, sir?
Yes.
Okay. All right. Summon our jurors, please.
Simple as that. For the most part, a lot of his questioning, although entertaining, is pretty evasive, and not much testimony comes out of him, except Ms. Hilton is in the early stages of trying to identify who certain players are for later. But after about an hour into testimony, Judge Glanville calls for a 10-minute comfort break, and as soon as the jury's out of the room, he says that there's an issue that needs to be taken up with Ms. Bumpus. But remember, Ms. Bumpus is the one that was present as the attorney, as counsel for Kenneth Copeland, or Woody, while he was in that ex parte meeting in Chambers with the judge. And even though the judge wanted Brian Steele to say in open court, for the record, who it was that told him, I am pretty sure that the judge has suspected that it was Mrs. Bumpus.
Okay. Before we call in our jury, it has been brought to the court's attention that Mr. Copeland's counsel, Ms. Bumpus, would like to be released. Is that correct, madam? Yes, sir. Okay. All right. Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer the job right now.
I don't want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
What I need a lawyer for?
Right.
What
No, it's just the court is just asking you whether it's your choice, sir.
I'm good.
You're good?
Yeah.
Ms. Bumpus, did you file an entry of appearance? All right. Did you, under the Uniform Superior Court rules, file a motion to withdraw pursuant to the Uniform Superior Court rules? I mean, I know you give an oral notice, but usually it has to be in writing, and he has 10 days to object.
So the problem with this is Woody can fire counsel at any time. The application to withdraw would be if the attorney wanted to withdraw from representing somebody. They would have to make a motion, the judge would have to rule on it to give them permission to withdraw. But if a client says you're fired, that should be enough. But there's an additional layer here on top of that Ms. Bumpus is going to argue that, look, I only stood in to represent Mr. Copeland during, these communications while his actual attorney, Melnick, is away on vacation. I was just temporary, and I was here for the purpose of that ex parte meeting and working out that contempt that was issued to him on Friday. But with that contempt order being purged, my work here is done.
Say again.
I was never his counsel. Attorney Melnick was his counsel, and I was stepping in as a courtesy for judicial efficiency. But if the court desired for me to file a motion to withdraw,
Well, given the fact that you have represented Mr. Copeland at this point in time, it would seem appropriate that you do need to, in fact, file a formal withdrawal. Even though you didn't enter one, you de facto entered this case by your representation of him, or you telling the court that you did, in fact, represent him. So at this point, I'm not inclined to release you until that's done.
I'll get that done now, Judge.
Okay. All right. And he's got 10 days to go ahead and do that. So you're still going to have to be here until because he gets that particular period of time to go ahead and decide whether or not he'd like to hire a lawyer. That's the whole reason for the 10 days.
Well, I don't want to hire no.
Hold on. Not yet. You get that right as a party. Okay.
Has the right to fire her right here, right now.
You get that right to hire a new lawyer. You get the right to do a couple things. One, to decide whether or not you will release her.
And he's
Two,
saying he does.
Whether or not you want to get another lawyer to be with you.
Okay.
Okay. Those are the two big things you get a chance to kind of decide. But what I'm going to do at this point in time is, since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw. But you're on the stand. You're testifying at this point in time. So I'm not going to let her withdraw at this point.
Yeah, he's on the stand. He's been on the stand since Friday. And you still called an ex parte meeting in your chambers and didn't disclose it to the defense to have conversations, ex parte communications, with a witness that's sworn in. Yes, Judge Glanville, we know that he's in the middle of testifying.
Well, Your Honor, I'd just like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of. So, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point. I'm sorry that you put yourself in this particular situation with you and Mr. Melnick and whatever, but, Mr. Copeland does have rights in this particular circumstance.
He has the right to fire counsel, effective immediately.
File a proper notice to withdraw. I'll give once it's filed, if you file it today, I'll give Mr. Copeland the 10 days. But until such time as I rule upon that and he gets that and gets an opportunity to think about what he'd like to do, I'll go ahead and insist that you remain with us while he's on the stand.
Okay, Judge.
Okay. Madam, I have one other bit of business.
Can we approach? Can I approach, Your Honor, with the state?
No. What does he want to tell me?
I don't want to say it in open court.
Look at his body language. Let's run that back.
Can we approach? Can I approach, Your Honor, with the state?
No. What does he want to tell me?
I don't want to say it in open court.
All right, State, Ms. Bumpus, come on up.
State and Miss Bumpus, come on up. Guess who we didn't invite up?
And I don't believe you have the right to be present, sir.
State objection, whatever. I do think we have the right to be present, and I think there's case law for that. We are now being excluded from a conversation about material witness in prosecution, state versus non-dependent, and a conversation between the court and that counsel for that witness and the state, which are now conducting a meeting with the court without the ability for me as the attorney for the defense in our case to be present and knowledgeable about those conversations. And I think that that ex parte communication creates an appearance. I say this with tremendous reservation, and I almost want to apologize for saying it to me, but I think it creates the appearance of impropriety and bias on the part of this court. And I don't mean to suggest Your Honor is doing that, but it creates the appearance of it. So I have to check. Okay.
Impropriety.
I'd like to just add, I'll adopt everything that's now said, but I'd like to just add also under Article 1, Section 1, Paragraph 12 of the Constitution, it also denies Mr. Williams his right to a critical stage of the proceeding.
And sorry, Your Honor, if I could just add to that for the record. I'm going to cite to the Uniform Spirit Protocol 4.1, which prohibits this type of communication. I'll cite to the Georgia Code of Judicial Conduct, Rule 3.4, which prohibits this type of communication. And I'll cite to the court several cases which I believe support that. The first is Monday versus Magnolia Advanced Materials, which is 815 Southeast 2nd 70. It's Georgia Supreme Court from 2018. I'm going to cite to the court Wynn versus State, which is 139 Georgia Act 355, 1976 case. The trial judge should not attempt to intimidate witnesses testifying on behalf of the state either in or out of the presence of the jury. And it also creates a presumption that the court should have to recuse itself. In that case is Curtis versus State, and that's 319 Georgia Act 432. That is the Georgia Court of Appeals case from 2012.
And he's dismissing the sidebar. He decides he doesn't want to do this right now.
Your Honor, I just wanted to be given an opportunity to be able to respond to that on the record and to point out that the distinction between the assertions by counsel for the defendants and what is going on here and the assertion being made that a trial judge should not intimidate or coerce a witness.
Neither should a prosecutor.
Actually, can we?
Yeah, hold on a second. Mr. Can I get you step outside for just a second? Let me finish this argument, please, sir.
They're going to have
Ms.
Woody
Copeland.
step out, the witness step out.
Yeah, just step outside in the vestibule if you wouldn't mind, sir, please.
What I believe that Ms. Bumpus wants to address with the court is strictly and solely the civil matter that involves the motion of the state to compel her client, Mr. Copeland, to testify, and the motion of the state to the court to sanction Mr. Copeland if he fails to comply with an order of the court pursuant to 24-5-507. That matter is a separate matter from the trial that is going on now. It is akin to the state moving the court for a material witness warrant for a person who refuses to obey a properly served subpoena. It is not something to which either defendant is a party. And for that reason, it is our position that counsel for the defendants are simply wrong in this instance. And that if Ms. Bumpus chooses to address the court with the state regarding a matter to which the state as a moving party and her client as the person for which the state made that motion are involved only, then the parties to that matter are the state and Mr. Copeland. And so for that reason, I believe that Ms. Bumpus is entitled to address the court with the other party in that matter, which is the civil contempt order entered by the court on the motion of the state at the time that the state moved the court to compel the testimony itself.
All right. I don't know what she's going to say, so that may make it not subject to ex parte or not. But what does he want to tell me, madam? Can you tell me the subject matter?
Yeah, about when he said he fired. And
Well, no, that we have to have a hearing on that issue. We have to have a hearing on that.
Okay.
We'll have to have a hearing on that issue. That's not an ex parte matter, okay?
Well, what I'm trying to say is something that happened during the ex parte matter, which is why I don't want to say it in open court.
No, I'm good. I'm good at this point in time. I think you need to go ahead and reduce it to writing and your request to withdraw, and your client, which we'll bring back in, your client needs to be able to have a say-so on whether or not you can withdraw.
So he's still deferring back to Woody. Your client still needs to have a say-so on whether or not you can withdraw. But he said, she's fired her. I already tried to fire her. And when Ms. Bumpus is trying to say, like, look, can we address this now? I don't want to address this in open court. Judge Glanville's just like, nah, I'm good.
And he should get another, and if he wants to have you and wants to get another lawyer. So that's it. No, it's not gonna be ex parte, okay? Done?
She's about to make another argument here.
If there's no ex parte communication, then I'm withdrawing my objection.
Okay.
I just want to make that clear.
That's fine. You're doing your job.
With respect.
Okay, can we bring Mr. Copeland back in, please? Can we hold off until Mr. Copeland comes back in? Okay.
Yes, Your Honor. Just to put the court on the record, it's my understanding from last week's proceedings that Mr. Copeland was actually represented by Mr. Jonathan Melnick, and that the court required Mr. Melnick to be here on Monday. And Mr. Melnick indicated that he had non-refundable airline tickets and that he would have someone appear in his place. So I believe Mr. Melnick is still this gentleman's attorney.
We don't know that. We really don't know. I don't even know if he's entered an appearance for the purposes of this, the circumstance thereof, but I'm dealing with it from the standpoint of Mr. Copeland is on the stand. He's a witness. He's had counsel. He's going to continue to have counsel. So that's the reason I'm stating this at this point in time. Okay, sir? But thank you for putting that on the record, okay? All right, so Ms. Bumpus, file your motion. But until such time, you're going to need to remain as long as Mr. Copeland is a witness. And once we've had an opportunity to hear that, then I'll go ahead and do that.
This isn't going to be over.
It's not timely to begin with because he's on the stand, he's testifying, okay? So whatever arrangement you had with Mr. Melnick, I'm sorry that's put you cross purposes with not being able to be released. I don't know what difficulties it causes you otherwise, but I apologize on behalf of the court, on behalf of that. But
Your Honor, the state wanted to put something on the record as well, that Mr. Copeland has satisfied at this point his contempt by testifying. So if he remains and testifies, then unless he wanted to, there would be no purpose for an attorney. So long as he remains and he testifies, that's the only if he pleads the fifth or fails to testify will he be subject to being placed in custody. So at this time, he has purged or satisfied his contempt because he has testified.
So Ms. Bumpus is nodding. So the prosecution is stepping in and saying, Judge, let Ms. Bumpus go. Let Woody relieve his counsel. His order of contempt is lifted. As long as he's going to continue to testify, the reason that Ms. Bumpus was present as counsel in the first place isn't in effect anymore.
Remains in this posture, then we believe the contempt would be completed and he would not need an attorney. So, but I can't.
Well, but that's his choice. That's what the rule gives him 10 days.
And what was
to do.
his choice
We're
this
kind
whole
of
time?
saying, well, make that choice right now. We're telling him here in open court to do that. So that's what the court's concern is at this point in time.
But Your Honor, I was representing him for the civil contempt, not as a witness. So that once he purged himself, I should have been released.
The judge is quiet. We're Googling something. So I'm going to speed forward. He tells her to have a seat. She goes and talks to the prosecution.
All right, Ms. Bumpus. At this, go ahead, man. You can take the podium, please. At this point, the court is still of the opinion that you need to file a motion to withdraw and give your client an opportunity to respond to that.
Woody.
So, once you do that, and he has the opportunity to respond to it, I'll calendar it. In fact, for unless he decides immediately that he wishes to not hold your or require your services, but usually he gets 10 days. So,
And how would
require your services, but usually he gets 10 days. So,
and how would the court know if he's deciding immediately? Because
well, usually he's hearing. I mean, you know, we have either the time passes and there's no objection is filed, and you get it immediately with it's granted, or I said it for him.
So this is Jarble. Ms. Bumpus asked, "How would we know?" And he's like, "Well, if time passes, then immediately." What?
how would the court know if he's deciding immediately? Because
Well, usually he's hearing. I mean, you know, we have either the time passes and there's no objection is filed, and you get it immediately with it's granted, or I said it for a hearing, and he says, "Yes, I either don't want you as attorney, or I want to have you as attorney. Or I'm going to get new counsel, or I've gotten new counsel."
and so Jonathan Melnick is just able to be released.
See, I don't know what the arrangement was between you and Mr. Melnick. I have no idea. That's not my purview. All I know is that Mr. Melnick was here on Friday. He said he was going on a vacation. I don't know if he even properly entered an appearance in this case. I know that his leave wasn't appropriate in this case because he asserted himself as and represented to all concerned that he was in fact Mr. Copeland's attorney. So, and then Mr. Melnick said that he would have counsel for Ms. Copeland on Monday, and that was you. And then you appeared on Monday. So I do think that you do need to properly withdraw and give your client an opportunity to do to have the full range of options. So until that's done, now Mr. Melnick may come back and may decide, well, yeah, I'm going to pick up, and I still represent Mr. Copeland, but I need to. I'll take up that issue when it was presented before me. Okay. All right. I'm going to set that, madam, for the morning of the 25th of June at 9 a.m. All right.
The judge thinks we're good, but
Let's summon our jurors, please.
Judge, may I speak?
Hold on, Sergeant Ingram. You want your your lawyer's not in here.
She's not my lawyer.
No, but you still have the opportunity to decide that, okay? All right. Your client wanted to say something, and he said, "You're not my lawyer." But as I told him, I was about to tell him that he has the right to decide that issue, and he has to be given due process to decide that issue. So that's why I want that done in this case, okay?
Okay, Judge.
Okay, all right. So at this point, anything else? As in respect to Ms. Bumpus?
You didn't give me time to say that.
Okay, I'm sorry. What else did you want to say?
Mr. Melnick told me that she was only going to be here for 1 day. And that she was going to make sure that after she's done then, it was going to be.
See, but I have no knowledge of those discussions. And because they asserted themselves as your lawyer, you have certain constitutional protections as being represented by an attorney. I don't know what was said to you. I don't want to know what was said to you, but I'm just looking at who showed up and what they told us, meaning that me and the other parties here. So I don't know, and that's my kind of pause in this particular circumstance is that, and I need to find that out. So filing a withdrawal would help the court in this particular circumstance. Yes, Mr. Abb.
Just briefly, Your Honor, my application is always to help educate and inform the court. Uniform Superior Court rule does indicate that the 10-day requirement is made if the client consents to a term of withdrawal.
I tell you what, Mr. Copeland, I'm going to send our jury to lunch. I'm going to let you talk with Ms. Bumpus afterwards, okay?
All right.
And then during lunchtime hour, and then after that time, I'll go ahead and make a decision at that point, okay?
Yes, sir.
All right, okay.
so after lunch, Ms. Bumpus gets back up to the podium.
Let's good afternoon, madam. Again. Okay, did you have an opportunity to talk with your client, Mr. Copeland?
Yes, Judge. Can we talk about it?
Yes, you can. Go ahead.
Yes, and I got him to sign a written consent discharging me. I filed a motion to withdraw, and I proposed an order.
Okay, can I see it, please?
Madam Pro?
You can. I'll mark this as the next court's exhibit in order. Do you have a formal order that you're going to prepare with the style of the case and the case number?
Yes, Judge, that's just his signature. I prepared an order and I filed a motion with the clerk's office.
All right, okay. Mr. Copeland, let me hand you. This document. Did you read and sign that document?
Yes.
All right. Did you have an opportunity to talk with Ms. Bumpus, your satisfaction about pros and cons of her withdrawing as your counsel in this case?
Yes.
Do you wish for her to go ahead and withdraw as counsel?
Yeah.
Okay. All right. All right. Let me have that back in mind. Okay, I'll mark this as the next court exhibit in order, madam. We got it. We'll just mark it as the next court exhibit in order. Do you
So
need
he's
a copy
finally
of it
going to let her withdraw as Woody's
part of the
counsel.
record, but do you need a copy of it?
No, Judge.
Okay. All right.
But he still wants
all right,
an
so I
order
will
to
go
show
ahead and
cause.
authorize you to withdraw as his counsel in this matter. Okay.
Thank you, Judge.
As a result, I'm going to also have you appear on the 25th of June. I have filed an order to show cause, and
We're about to
give
look
you a
at.
copy of it. You can read it, acknowledge it, just that you received a copy of it, and we'll see you on the 25th of June at 9:30 in courtroom 1C.
All right.
So you need to be here for that day, okay?
Okay.
All right. We'll see you then.
Just as a reminder, I was fast forwarding through all the dead air, all the recesses, all of the, people entering and leaving the courtroom, and it still took that long for Judge Glanville to agree to relieve Ms. Bumpus. We're going to look at this order to show cause. It's real short. And I want to know your thoughts. Why do you think Judge Glanville still wants Ms. Bumpus to come back? What does he want to find out? What does he want Ms. Glanville to talk about? Could it be that ex parte meeting? What or who disclosed something, if anything? Let's read this. So this again was just filed right when he said that was like around 3 p.m. today. The court having been presented with an issue of contempt for determination, all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10th, 2024, to include the witness, Mr. Kenneth Copeland, his attorney, Ms. Kayla Bumpus, and all representatives of the state and the court security personnel that were in attendance, are hereby ordered to show cause before the Honorable Ural Glanville on the 25th day of June 2024 at 9 a.m. in courtroom 1C. Why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel. So when he first brought up this 25th, this day of June, he played it off like it was just going to be, oh, we still need to have a hearing for you to be able to withdraw. But then even when he allows her to withdraw, she does all the paperwork right then and there, gets the signature from Kenneth Copeland or Woody. He still sticks with that same 25th. He already has the order to show cause ready before he permits her to withdraw. What was his original goal when he said we need to have a hearing? What has been his goal this whole time? So he says it's further ordered that the failure of any of the individuals who were present for the June 10th, 2024 ex parte conversation will cause the court to direct the Fulton County Sheriff's Office to take them into custody and bring them to the bar of this court, so ordered on this 11th day of June, 2024, signed by Judge Glanville. So honestly, you guys, I really wouldn't be surprised if we see some of the same criminal defense attorneys that showed up yesterday to advocate against the contempt charges against Brian Steele respond to this order to show cause. In my personal opinion, this seems like an order to bring everyone together to possibly hold them in contempt for an ex parte meeting that the judge hosted, because information about that ex parte meeting was disclosed to the defense. So to me, it just seems like the judge is doubling down. That's just my opinion. I'm open to hear your thoughts. I'm open to hear your perspectives. Anything that you have going on at all, you let me know in the comments. And as soon as we get some more action on this, we'll talk about it. You guys all take care. See you next time.